All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for the last day of March, March
Yay.
31st, 2025. Brad, go ahead.
Well, we're not going to do this on April Fool's Day because nobody would ever believe half the stories we present anyway, but let's do that regardless. So let's start in New Jersey. This is a little convoluted, and it's funny. I got to say, of all the cases we're doing today, I'm not sure I believe many of them. So it's hard to know. I'm not saying that with regard to this one, but some of them raise questions. So I'm going to
Yeah.
raise the questions.
Yeah.
But most of these are just lawsuits, a couple are court decisions. So first, we're going to start with a suit, right? Which we only have the one side of the allegations. We're in New Jersey. And what we have, it's a little strange. We have a former employee of the Bayonne Fire Department Fire Protection Bureau. He filed suit claiming he was falsely charged and then maliciously prosecuted by the city. And the allegations is that the charges were levied because he refused to cooperate with an investigation of another employee. And, basically he's brought into a room, he alleges, right? All allegations, we don't know, alleges that he's brought into a room, not Mirandized, not given any access to representation by an attorney or by the union.
And brought in by a police officer.
But yes.
So,
And was told that it was non-custodial, maybe, right? And these all get into Fourth Amendment. Did they know they can leave?
fourth,
Were they
fifth,
free
and
to
sixth.
leave?
Fourth,
Yeah.
fifth, and sixth. Yeah.
Yep. And this, and whether they actually were free to leave and all that. In any event, the charges were thrown out. So once they're thrown out, allegedly on the merits, and I question that, frankly, because if it's thrown out on Miranda grounds or not, right,
Or
that's not
Garrity.
on the merits.
Right.
That's procedural. So normally a claim for malicious prosecution, which they're claiming here, and there's more facts we'll get into, it requires a dismissal on the merits, not necessarily just procedurally. So that's why I'm kind of questioning this. In any event, that's part of the suit. But the plaintiff was asked by the defendant, the city, and employees to speak out against another employee and who they wanted to terminate, and basically said, we're not going to do that. So the plaintiff allegedly refused to be part of that investigation. However, the plaintiff became aware of an investigation of clerical errors, right? And was then brought in, I guess, when they wouldn't participate or something. But after this custodial interrogation with a police officer without Miranda, they were then said, you're my guy, allegedly, and then he was being arrested. So the courts, and I know these cases because I love constitutional criminal procedure, and these issues are a big one for me. Generally, when you're arrested immediately following an interview, there is such a high probability it was a custodial interview. It would be different if it was weeks later and, hey, we're circling back to you, but not in this case. In any event, he was suspended without pay. He was provided a preliminary notice of disciplinary action. He finally got criminal defense counsel, right? And then finally, after all that, it's all dismissed for lack of evidence, maybe. I presume that's what it was. That's what they said, lack of evidence. But that's possible, right? You could throw out any admission, you could throw out anything that was said in a custodial interview that was improper, and then the charges lack all the evidence, which is very possible here. That's exactly what happened. That would be a dismissal on the merits, so that would be good for them. In any event, so they're basically saying, now listen, one is I was unfairly prosecuted, improperly prosecuted, and then I ended up being terminated anyway. And the defendants, they allege, keep engaging in a pattern of racketeering activity that at least two predicate acts. And that's what's interesting about this. I think it's all interesting. I've never seen this happen this way, where you're brought in to talk about one employee. You say, I'm not going to cooperate. Somehow you get arrested. Like, were you brought in on false charges? Were you brought right under the false premise you're supposed to be talking about someone else? Did they just retaliate against you because you refused to cooperate? I don't know. And now you allege not only malicious prosecution, but also a RICO Act, a conspiracy to commit crimes act. That's unique. I have not seen that.
Yeah, there's a lot of issues here, and there's a couple of reasons why a police officer may be interviewing a firefighter about something that happened at work, and one is a criminal investigation. That's the most likely way. However, some fire departments don't have the internal capability to do disciplinary investigations, and they haven't really thought about it because it doesn't come up all that much. So they contact the police chief, and the police chief says, "Hey, you can use one of my investigators." So now there's a question about whether or not this police officer was doing a criminal investigation. Certainly, when you arrest someone afterwards, it appears that it was a criminal investigation from the get-go. But it's not all that clear when it's the same, like it's not like a county sheriff doing an investigation with city fire department. It's the city police investigating the city fire. And why that's important is if that police officer was doing a disciplinary investigation and the firefighter, I say firefighter, looks like he was a civilian employee, but the employee asked for a union rep, Weingarten applies. If
Yep.
it's disciplinary, Weingarten applies. And the failure to, and the amazing thing about this lawsuit is they don't mention Weingarten,
Right.
which
Shocking.
totally blew my mind. How did they miss that issue? And maybe they've got a civil rights attorney that's not an employment attorney. Maybe that's why they missed it. So, but at any rate, if it was a disciplinary investigation, now Weingarten has nothing to do with a criminal investigation, and I think that's more likely. This was a criminal investigation. He asked for a union rep. He was declined. He asked for an attorney. Okay, so now if this was a disciplinary investigation, he has no right to an attorney. All right, there is no legal right to an attorney. It's certainly advisable to let him have an attorney. But if this is a criminal investigation
And he was arrested.
and he asked for an attorney, you got to give him an attorney. If not, now anything that he says cannot be used against him. Okay.
And that ultimately is probably what led to dismissal on the merits, because they had to throw out everything they collected from him. They had no more evidence.
Right. And so there's that part of this is very it's confusing, and it's why whenever there's a possibility that a firefighter has committed a criminal offense, you really need to slow down the investigation, and you need to kind of move forward in a very deliberate way. And if there is a criminal investigation going on, we need to separate it. And police departments have to do this every day because you and I shared an article with you about a police chief that got himself in trouble, and through all we would have to do is change the police chief to a fire chief, and you say, oh yeah, that happens all the time. But just the idiotic things. But police departments hire from the same gene pool as us, and they have the same problems, and they have to bifurcate their processes. If you have a police officer who's accused of dealing drugs, you have a criminal investigation going on by the drug unit or whomever, the detectives, and then you have an internal affairs or professional standards investigation going on by the professional standards folks. And they can share information up to a point, but once you call the firefighter in for questioning, that's where things start to get complicated. And this is one where we don't know all the details, but it's an example of the problems that can arise when you start calling in one of your employees for possible criminal conduct on duty.
And this one has all the smatterings of being very truthful, because they're pretty bold statements, if it's not true. So I am guessing this one is, probably a very good case of malicious prosecution.
It sounds it, but again, we just don't know. And what if he actually was guilty of the underlying offenses? We're not saying he is, we don't know, but if he was guilty of the underlying offenses and he got to get out of jail free card because the cop screwed up.
Right.
And now he's going back. I don't know. I mean, you're going to have to let the system kind of wash out all of the irrelevant details and get to the heart of it. But complicated.
Very, extremely. As are, frankly, many this week. So let's go to Orlando to visit Mickey Mouse.
Yeah.
And here we have a district chief alleges a disability and gender discrimination. So twofold. And I'm surprised there's no retaliation. There's always retaliation following, right? They always a tag along claim. But in any event, So
Well, she did allege retaliation.
oh, did she? Oh,
Yeah,
good. Okay,
yeah.
good. So so the allegation here is that the city discriminated against her on account of her disability and her gender. And she says a new fire chief, let's see. Well, let me describe her. So she's African American, Black woman. She claims that certain duties were taken away from her and that an accommodation, this is important, that was previously granted to her were changed. All right. And she claims she has an autoimmune disease. That's her disability, and that she was previously accommodated for it. And she also alleges that she's retaliated because she's being treated differently from other white men as a result of being female. So the short of this is, and these are all long stories always, but we've got July of 22. The defendant, right, has a new fire chief. And when you get a change in circumstances like this, there's a good element of truth to it. It appears truthful, like, well, what changed? And start off, we have a change in 22. We have a new fire chief. So, probably it gives some smattering of truth. And in any event, the new chief allegedly, all right, and his executive deputy chief allegedly began to implement policies and procedures that were discriminatory. Now, I'm questioning, were they on their face discriminatory? Were in their application, were they discriminatory? Because then this could have led to a Monell type claim, right? Which I'm not sure we see. In any event, apparently that these new policies and procedures, which we'll get into, did affect her previously approved accommodation. And that accommodation, by the way, as I recall, was being able to work a 40-hour week in a certain job title as opposed to maybe a much longer week. So starting
kind of ambiguous about that. I'm not sure that it was a 40-hour week. There was some sort of an accommodation made for her, and I'm not sure what that is, but certainly moving her off of that 40-hour week violated that accommodation.
Yeah, I mean, the claim was that in May of 18, the prior part is May of 18, she made a request for a 40-hour week.
I think there was also
some
time off that she was granted. She had some flexibility to provide care for a minor child. So there was also some other accommodations beyond just a 40-hour week, I believe.
Okay. And so she's claiming that in a couple of month period, which is interesting because between August and October, right? And I'm just stopping here. When people say, between these couple dates and not over a year or 2 years, it sends me to the other time of, well, wait a minute, that's a short time to discriminate. Like why just for that time? In any event, she claims in that couple of months in 22, she was subjected to a hostile work environment. And that environment included disciplinary actions that weren't true against her and interference with her use of sick time. And then she says in August, and being specific, she says that the deputy chief refused to give her the lieutenant's exam prep something, right? A prep course or prep program that other similarly situated white males were given. So she's being treated differently than that.
I believe that she was responsible for administering the exam, and they took that job away from her as I read the complaint.
Oh, okay. And it's possible I'm combining two or three of these.
Yeah. So I can only put so much in the blog. Yeah. So there's additional details in there, but I think she had responsibility.
Right. It was part of her job.
And why that's important, Brad, the reason why I corrected that is that it's possible that there's been a problem with the lieutenant's exam, and they felt that she might not have been the right person to be continuing with the exam. So that could have been, and that's an important point here. Now, I'm not saying that is, but apparently responsibility for developing that exam was taken away from her. So that's what she's alleging was part of the change in circumstance here.
Yeah, and then there was this non-certified program that she was apparently in her job description, right? And she was removed. That was taken out of her job description. She was excluded from the meetings and given to other white male chiefs. That's where it was. And it was given, that job description was given to other white male chiefs who had less authority than she did. Now, look, just generally reassigning job duties is not the worst thing in the world. That happens for a million reasons. Doesn't mean it's discriminatory. All right. So I'm not sure why just, if they said they took everything away from her, that's what you normally see, right?
Right.
In any event, so she goes on further. It says in May of 23, the recruitment marketing campaign was taken away and given to somebody else. So now you start seeing okay, I keep losing my jobs. That's what you normally see. And then there in October of 23, there was an email sent out by the deputy chief announcing transfers within the department. Now, this I get a little hazy on, but so defendant, the deputy chief or the chief transferred her to a field position, but there was no existing vacancy in that bureau, in the field operations bureau. So it looks like, well, why was I transferred? Was I transferred, as retaliation or discrimination? So she told, on top of this, she then said she wants an ADA accommodation, which, by the way, she should not have had to ask for again, if that's true. Once she has the accommodation, you can't just take it away for no reason. And then she was told that, she said, look, I made that request in 18. I got a 40-hour work week. And that was granted back then in 18. Now, I presume, and it continued, right? Not just one time she got a 40-hour work week, if it was sick leave or something like that. In any event, the city attorney then allegedly says, well, you got to file another accommodation request, which, again, if it's the same one, you don't have to keep recertifying unless it's like a temporary disability or something.
Let me ask you that. Can a fire department have a policy that says you got to recertify? No.
Not if it's a continuous non-intermittent disease, right? If it was intermittent, maybe, but no way. You can't say you have to keep coming back. You have a disease that's not going away or a disability that's not going away. No, you can't keep saying that. Now, maybe one time. Now, the one thing in this, though, is if she was transferred to a different position and then that could potentially allow a new request for accommodation because maybe the position changed, right?
Well, I guess my concern, giving advice to fire departments, and I'll go based on what in Providence we were told by city legal, and I agree with, I think, is that if you're a line person, you're hired to be a line person, and we give you an accommodation because of a medical condition, there needs to be a time limit on that, that this is not an unlimited, we're not creating a new position for you for the rest of your career. Right. And that it's a year, and they recommended 1 year, that you can go on a light duty position up to 1 year. Now, I don't know what's going on.
But I can see why that is.
Orlando, but because otherwise, you have one person, now we create a position for them for the rest of their careers. Now we have another person. Next thing you know, we're having trouble staffing the trucks because we got all these people hiding at headquarters with all these jobs, and we're paying overtime to backfill the trucks.
Yeah, look, this is such a complicated, only because the facts change. It's dependent on the facts. If you said, listen, the accommodation I want was white light bulbs in my office, not fluorescent because I can't read, you're not reapplying every year, right?
Right. That makes sense. Yeah.
Right. So with some things, well, listen, we only allow 1 year of light duty, so we'll accommodate you for 1 year. Yes, that could, because we only allow 1 year. So the most we could accommodate you without treating you unreasonably differently than everyone else, right, might be a year. So there's so many different circumstances. Or maybe, listen, we have a temporary job, so we're temporarily going to give you this job, but we don't always have this job. But generally speaking, I think telling someone they have to reapply for an accommodation, if the job only allowed her, if her disability only allowed her to work 40 hours, right. I'm not making this up, but I may be stretching what they said, and I transfer her to a new job. Yeah, that may allow reconsideration of how many hours does she need to work or work. But here's the deal. It would be retaliation and violation of the ADA if I transferred her to a new job, which would not permit that accommodation, and there was no reason to transfer her. Then I'm just retaliating, right? So I don't know exactly why she was transferred necessarily. So that's really it. So that's right. And we don't have the other sides. I do think.
And there's one more thing that kind of stood out to me, is that she's claiming that she's got an autoimmune condition, but then she said the transfer was going to interfere with her being able to provide care for a minor child. That's not an ADA issue.
No, that's an FMLA issue.
Has some sort of a disability, but and then you start getting into the FMLA. But
Which raises the question then, could this be an FMLA accommodation that was granted? And, but it doesn't look like they claimed that.
No, they didn't. It's just ADA. Yeah.
Yeah. So, but they rescinded the transfer. So I don't know.
One other thing stood out, and I've had this happen to me. I've had some African American firefighters come to me and allege that, they didn't, one in particular, I didn't get promoted. I should have been promoted. I didn't get a transfer, those types of things. And when I suggested we ought to include a count of race discrimination, they said, absolutely not. And I said, why not? No, I don't want to go there. I don't want to go there. And the reason I say that, she didn't go there. She didn't allege race discrimination. She did allege gender discrimination, but she didn't allege race discrimination. And the reason I say that is it's not uncommon. She probably could have, and who knows, she might at some point. But I think,
but it's weird though, because she keeps, so for example, I go back to something I was saying before, she complains about her transfer. Another transfer was rescinded, right? Because and she says a white male, right? Because he had childcare issues. So they did something where a similarly situated white male. Why does she keep saying white if it's irrelevant?
Interesting. Yeah.
It kind of makes no sense to me, but any event. Okay. So, but I gotta say, like, if I'm HR, I got to keep asking my people, why are you doing these things? Why are you transferring? Why are you doing this? What is the reason, right? Why you're doing this? If I'm HR and I don't know, it is the role of HR, whether HR feels so bold or not to question the chief, but HR should have power to question the authority of everybody and the rationale of why people are doing things to make sure they're not discriminatory. One would think if there's an HR department here, and you would think there would be, it's a city, right? Then why, how did this pass the smell test? So maybe there's something else that obviously we got one side.
With a lot of these cases, we're only getting what's come to the, certainly either in a complaint in, court documents or that reaches the news media. So we don't know what's actually going on, behind the scenes. So.
Okay, for a totally different type of case, we're going to go to New Hampshire, which is great. A New Hampshire court reversed what I call PERB, PERB, if that's what they use, PELRB, they do in this state.
PERB.
Right? Either of that. But it's the Public Employee Labor Relations Board. And they ruled, and a court reversed, that the police and the fire should be they have a community of interest, and they should be under the same union bargaining, et cetera. And I think that right off the bat shocks everybody. But what's important about this case, if it ever comes up to you and they try to put you with DPW or police or anybody else, is the tests that the court goes through to determine that there is not a sufficient community of interest, right, here, and that they should negotiate jointly and bargain jointly. Doesn't make any sense. But they go through the test, right? And the court says the principal consideration in determining a proper bargaining unit is whether there is a community, if that's how it's supposed to be, of interest in working conditions such that it is reasonable for the employees to negotiate jointly. And here the court goes through and says, no, right? They're totally different jobs. So
the PERB said yes, but the court said no.
Right.
And there's a couple of comments in social media on this one, and I think it's interesting. Like, why would they want to be together? And it's obvious they're a small union. I think there's 5 or 6 police, 5 or 6 firefighters, and there's strength in numbers. And so they wanted to be together for their mutual protection. That, again, strength in numbers. But again, regardless of that, you've got to have that community of interest. And I included a lot of the quotations from the court in there, so you can look at what the courts and what the PERB should have been looking at, but what the criteria is for that community of interest. But
yeah, just quickly, because some of them are really interesting. They said they work different hours. The officers have very little in common with each other, like police officers and fire lieutenants, totally different hours, different circumstances they work under. you know, and just because they're subject to the same terms and conditions in the personnel policy doesn't make that have them the same interest. So the court really, you know, very different duties, and they are. It did occur to me, though, I wonder why I get strength in numbers, but a lot of times there's this circle where police get a raise, and then fire said, wait a minute, we should get a raise. And then police get a raise, and fire says, we should get a raise. So you're right. That's would have been taken away here if you joined together. You can't point to each other.
It's interesting. And we studied that. I took a class in law school on public sector collective bargaining. And it raises an interesting issue where you talk about is parity, and which makes sense for certain things like wages and different things. But let's say the police get an ammunition allowance of so many rounds a month for target shooting and all that, and the firefighters want maybe a second set of turnout gear. And so, how, you know, what's the parity? Is ammunition the parity for turnout gear? You know, like, and in the context of negotiations, are if there's 6 firefighters and 5 police officers, are the firefighters going to get their turnout gear, but the police are not going? And that's where the community of interest starts to come in.
Yep.
So
very interesting. Okay, one I'm really going to beat up on. I'm sorry, but I really am. We're in Michigan, and there's a lawsuit now, just a suit against the Michigan police and the fire departments. And I'm sorry, this just so lacks credibility for so many reasons. And if it's true, I apologize. But just reading what I read, there's a lot of questions. So we have a wife suing for her husband who overdosed in 2022. Claims that and I got to tell you that part of the fault is the lawyers. You're going to laugh in a minute, but they claim the police and firefighters failed to render appropriate aid to her husband and other civil rights violations. So here's the interesting thing. So he dies in March of 22, but before that, they encounter him in a traffic stop, and they allegedly, right, he explicitly, and they're being very specific about this, so explicitly informed the officers that he had ingested 4 Xanax pills. Now, the lawyer didn't catch this, but I am going to in a minute. He says he ingested 4 Xanax pills, and that's far in excess of the recommended dosage, which they allege created a clear and urgent medical emergency requiring some intervention. But then they let him go, right? Even though he has a cough and displaying clear signs of an overdose, allegedly not being able to breathe well. Now, look, they're body cams, I'm hoping, right? Hoping but I don't know here. In any event, in the police officer's report, it said that the individual kept coughing really bad as he was choking. So, right? And then it says the defendant, this is half of the claim, and we'll talk about the other half in a second, but I'll take a break in between. And they said defendants took no immediate action to seek medical attention, and that the police ignored his rapidly deteriorating condition. But here's my first question. Was he alert and oriented? Did he accept care? Did he refuse care? I don't know that, but that's my first question, right? Because if he said, listen, I don't want to go with you. You're the police. I want to go home. And you could see why you might just want to leave instead of being taken into actual custody or alleged custody where, I'm going to the hospital and then I know I'm going to get arrested right after the bat, right? So maybe he said, no, I don't know. And again, this is a complaint, but that's my first thing. Something's a little weird. I just have a hard time believing that there's not something more when the police are allegedly putting in their notes, he's choking really badly. There's a reason that he didn't go with the police or an ambulance at that time. In any event, remember Xanax, this is going to come back to haunt somebody. And so they say they just let him leave without medical supervision. And then that EMS had to be called back, and they failed to transport or treat the guy for further medical evaluation. And they said, he was experiencing problems from the Xanax or something. And they say, well, you didn't use Narcan. And you should have used Narcan. Well, Narcan doesn't treat Xanax. So is he overdosed on heroin? Sure. Right. But Xanax, that's not. So something's not right. And then they said, finally, they did give Xanax or Narcan and he wakes up. Well, none of this makes sense to me. In any event, they basically, and then they said, this is my favorite. And you got there and somebody was doing CPR and you allowed them to continue doing CPR and he was untrained. I don't care if he's untrained or if he's a doctor. If he's doing effective CPR, then keep going, right? I'm not going to interrupt someone unless they're right. Let's do the ALS stuff and everything else, set up the monitor, etc. You keep going with your CPR, it's good. So that's not negligence necessarily, right? And by the way, he's already dead, so you'd have to prove that effective CPR would have saved him. Almost impossible to do in this case. And that, I think, really kind of summarizes a lot of this. I have a hard time believing some of it, but again, I'm not questioning what they say is true or not. It just doesn't make a lot of sense to me.
There's an awful lot of questions in my mind too, and that's why I kind of left it. I didn't call out that issue on Narcan and Xanax, but it's I don't know. I don't know.
It's iffy. It's iffy. It's so iffy. Is it really true? I don't know. But maybe, who knows? And again, hopefully there's body cameras, and this is exactly why you should be wearing body cameras, both EMS and fire. And look, we talk about body cameras on EMS all the, we think it's a good idea. Look at the police. It is a good idea, and you can protect
Absolutely.
it and secure it. And
I was watching body cam video on a YouTube video last night of a police officer who pulled over a state representative, and the person was giving the police officer a hard time. And I think that it was a young police officer. That officer could have gotten himself in a world of hurt if he didn't have that body cam on. So hopefully police officers today, I know back in the day, police officers resisted, body cams. And I
now
still
they
hear
need
some
it.
talking that they, all they do is create problems. But I really think that there's a big advantage for the protection of the officer. And I say that as the father of a police officer. I think it's going to, in the big picture, it's going to help. And I think an argument can be made also for EMS personnel as well.
Oh, I definitely. What do you have to hide?
Yep.
Right? If you don't do anything wrong, what do you have to hide? If somebody accuses you of stealing something from a wallet, what do you have to hide? Let them see where your hands were. If a patient says you did or didn't tell them something, or now we can see exactly how the patient presented, what do you have to hide? It is such a good idea. And I think, pick Brown, Floyd, whatever case you want to choose, it would have helped, or, if your mindset was right,
it documents the truth.
Yeah.
It documents the truth. So,
okay. So finally, is this finally,
Yeah.
I think,
Yeah.
we are in Idaho. And we have a fire department who's accused of retaliating against a whistleblower. So we have a female who's a community risk reduction specialist, right? And CRR is a great thing. It's generally not firematic. Sometimes it's out of the line, so to speak. And she filed suit claiming she was disciplined and then ultimately terminated as a result of whistleblowing, saying that the data being used was inaccurate, and it's being used to, I don't know, cover up something. I didn't totally get
I've got some friends involved in this one, so I'm going to come out with a little bit of bias, or admit a little bit of bias on my part, but I'm biased in favor of the fire department here. And this gal was only employed for a matter of months. She's contradicting, high-ranking chief officers who spent 20, 30 years in the fire service about how to calculate standards of cover, what should be and what shouldn't be considered accurate. And
and yet play that out.
I'm going to zip it after that.
No. But let's, and rather than get too much into this, right? Because you can just go through. It's always the same thing. She complains. They start retaliating against her. She's ultimately terminated. And she says it was all because I started complaining about the accuracy of the data. Flip the switch for a moment, right? And say, no, wait a minute. You annoyed us. You were a pain, and you were either right or wrong on what you reported. We took care of it, and you were constantly needling us. And yes, we are retaliating against you, but because we don't like you, which is acceptable, as opposed to you reported
because
something.
You're creating so much of a disturbance in the workplace that we can't get work done, and you're not a good fit for the organization.
And that's, look, that's why, at least in New York, civil service rules where you get a year of probation, right? That to me makes sense, because you may test well, you may know your stuff, but the personality doesn't come out in an interview. It's just not. And it's not until you work somewhere for a couple of months. So this is so common. What you and I will tell everybody is document document. You verbally counsel someone, you document. You have an issue where you had an argument with someone, I would be documenting why you said or engaged in that discussion. Document. And, you talked about it. You were at my conference in Oneida County, New York, and you talked about toxic individuals. And I got to tell you,
I don't want to go suggesting that that's the situation.
No, I'm not. But
yeah.
To me, as I listen, and by the way, one of the most interesting sessions I've ever sat in on. But to me, that's the type of questions somebody should be asking. When you have trouble with someone so immediately, they're going to keep being a problem. Presumably, you better start documenting, because I'll tell you what, they are. So you might as well have something else. I would document everything. I would use evaluations. I would use reprimand forms. I would use write-ups. I would use letters and emails, carefully written and reviewed. I mean, that's what I would be doing. So who knows what the real truth is here.
And again, we don't. All I know is I've been to that fire department. I've got friends that are high ranking in that department, and I have the utmost respect for them. And I just find some of the allegations hard for me to believe.
Right. Agreed. Well, that's it. But hopefully we've given people some good practices and to take dealing with difficult people, right? And whether they're problematic, difficult, is their fault, our fault. Hopefully people do not just push this aside, because they are not going to. You need to write down everything that happens between you and the employee.
Yeah, and I think this week, and I think if you look at our body of work over the course of years here, folks get a sense for what are the issues that fire departments are facing. We've gone from employee related to incident related to collective bargaining related concerns this week. So, there's a smattering, and it's not the same stuff, week after week after week, but there's a broad range of legal challenges that we face.
There are definitely common themes. Yep. And on each theme, I will tell you, documentation, whether it's documentation by body cam, documentation by paper, you need a way to prove the truth. Look, every lawsuit is allegations, right? Every lawsuit is a fact of allegations. If you can prove those allegations, great. If you can defeat those allegations, great. But everything is about facts. The more documentation you have, whether video or written, is going to protect you. And that, chiefs, is you need to be spending so much time writing and documenting something down. At this time, this happened. Here's what's happened. And if you need to, hand them a report and say, here's what I just wrote. Sign it, disagree with it, whatever. But here's what happened. And get their say on it, the employee's say.
All right.
Okay, here we are.
That's going to do it for another edition of Fire Law Roundup. Brad, we'll see you again next week.
Have a good one.